we're going to provide details on the new California Independent Contractor requirements called the ABC test that became effective on April 30th, 2018, and we'll cover the potential liabilities that can be imposed from noncompliance and the steps for converting independent contractors to employees. Before we get started, I want to give you some info on how we're going to use our Q&A. You should have a bar that has a little Q&A tab, and from there you can click on it and you can write your Q&A. And we're going to save all of those until the end. If you see a question that's the same as yours, or it's something that you want to know about, you can upvote. There's a little thumbs up, and you could just click on the thumbs up and it will move that question to the top of the queue. So I want us to get started. I know we have a few more people joining us, but we said we're going to start at 10 and end at 11, so we're going to get going. I'd like to introduce our presenter, Alexis D. James. Alexis has practiced employment law in California on both sides of the equation, taking harassment, discrimination, and wrongful termination cases through trial and arbitration. Following 10 years as a plaintiff's attorney, Alexis realized that she could have more of an impact on workplace culture by guiding companies into compliance and away from costly and time-consuming lawsuits. Alexis and her business partner, Renee Noy, opened their firm Workwise Law PC in Calabasas and provides small to mid-market companies with preventative legal counsel, including management training, workplace investigations, audit, and hold on, change my thing, audit, and I lost my place. Like that, audits and drafting of customized policy. So I'm going to turn it over to Alexis, who's going to share her screen, and she's going to start the workshop. So Alexis.
Good morning, everyone. Can you see my screen? Nancy, can you let me know if the screen has been shared?
I can see it. Oh, no, I can't see it. Not there yet.
Not there yet. Okay. Hold on one second. Did it pop up?
Yep, you need to make it full screen.
Okay, there we go. Are we good?
Yep.
Okay, so good morning, everyone. First of all, thank you to Nancy and the San Fernando Valley Chamber for bringing me on to do this webinar today. And while I'm very happy to be your speaker, I wish that I could be talking about a legal change that made business owners leap for joy. Instead, I'm here to talk about the Dynamex case and the recent change to independent contractor status. And this case has made many employers feel uncertain about their futures. I've heard from many of our clients that say that if they have to convert their independent contractors to employees, that they will just have to shut their doors. I've also heard other employers claim that they will just ride it out and wait until there's a carve out for their industry based on the legislature or another case. And just as a reminder that this Dynamex case took 12 years to get through the courts up to the Supreme Court level when we now have this decision. So for those that are claiming they're going to just wait it out to see what happens, that's a risky position to take. It may take many years for us to get the carve outs that we're looking for if we want to protect, independent contractor status. So these points of view have legitimacy, but for now we have to face the changing landscape. And if we want to be in compliance, we have to do business differently in California. So today I'm going to give you a little background on what the Dynamex case is about and why there has been this shift to make everyone employees. And then we'll go through the steps of this new ABC test that the court established, which is the new analysis for determining whether workers are employees or independent contractors. So the history of Dynamex is it was a case about courier and delivery service drivers who were initially hired in 2004 as employees, and then the company decided to convert everyone to independent contractors to try and cut costs, not to have to provide workers' compensation and payroll. And 1,800 workers got together and filed a class action. And like I said, it took 12 years to work its way up through the Supreme Court. And the Dynamex decision is what we're dealing with now that says the test to determine whether people are employees or contractors. And the onus is now going to be entirely on the business owners to show that they've properly classified their workers, with the presumption being that everyone is an employee. So the courts are starting out with that presumption that you are now an employee unless you can prove otherwise. There are some minuscule exceptions for being independent contractors, but the courts have made it very difficult now for you to be able to justify that. So our traditional notions of an independent contractor is someone who does project-based work, not regularly employed. They control how their own work gets done. They use their own materials. They set their own hours. And our traditional notion of an employee is somebody who's controlled by the hiring entity. They're provided with steady work that is hourly or salary, and that the hirer determines how the work gets done, and it subjects their employees to wage and hour and taxes and work comp. And now after this Dynamex case, those traditional notions have somewhat been tossed out the window. So we can't just rely on these ideas to justify independent contractor versus employee. The court has said in their decision that even if you're hiring somebody on a very temporary basis, even if it's just a couple hours here and there, that there's no reason why they shouldn't be employees. You know, from a practical standpoint, it's very difficult for the employer when they're bringing people on such a temporary basis to go through the proper hiring protocols and get their work comp in place and get their payroll worked out. You know, administratively, it's a much higher burden now to have to do that, but the court is saying, you know, we don't want people to manipulate these rules and get around paying people properly by just having independent contractors. So even if it's somebody who's being hired on a temporary basis, you can still make them your employees. So why the big change? Well, the labor commissioner in California estimated that the state lost about $7 billion in lost payroll taxes. And so now there's this shift, which is going on in many different states, not just California, that, you know, the government wants to get that money back, that tax revenue back. And the way to do that is to make everybody be employees and have the employers take out the proper taxes and provide the workers' comp and benefits, you know, if that applies to the size of the business. So they don't want to be left out. It's a cash grab. What is difficult about this ABC test is that it really only applies to the wage orders in California. So what I mean by that is that when the court is looking to determine if you're an independent contractor or an employee, they are applying this for minimum wage, whether the person is getting their rest in their meal periods, whether you're providing workers' comp. So it really only applies to a very small subset of the labor rules. You can be an independent contractor under various other tests for federal taxes, and the other tests that the court looks at are the economic realities test, the control test, common law and other federal law tests, and state law tests. But the one that we are concerned with today is the ABC test in California for determining whether someone is properly classified for purposes of minimum wage, rest and meal periods, and workers' comp. Okay, so we're going to go through the 3 steps of what you need to prove to justify someone being an employee or an independent contractor. And the court said that you have to meet all 3 of these in order to justify someone being an independent contractor. It's not enough just to prove one of these 3 steps or 2 of these 3 steps. It's all 3. So just to read it quickly, the ABC test presumes an employment relationship unless the company shows that the worker has been and will continue to be free from control and direction over the performance of his or her work, and that the work is either outside of the usual course of business for the company requesting the work or performed outside of any of that company's places of business, and that the worker is customarily engaged in an independently established trade, occupation, profession, or business. So that's a lot of legal jargon. I'm going to break it down here. The first test, that A test, is really the way that businesses have been evaluated in the past. It's the common law standard of control. So is the hiring entity directing the hours? Are they providing the materials? Are they performing oversight for how the work gets done? That's that control aspect of the case. And previous cases, Martinez and Borrello, have used some more of those control factors to determine employee status. So really, Dynamex is just assuming that old test in prong A. Prong B is where everyone is getting into trouble now who uses independent contractors to perform their business. Because B says that if you are doing something that's the usual course of business, even if it's just one piece of that business, the court is going to say that person should be your employee. So for example, if a contractor uses framers to complete a project and the contractor holds itself out to the public as doing general construction, then the framers would be employees, not contractors. And I understand that there's some questions from members about general contracting, so I'll get to that at the end. We'll get a little bit deeper into that. And then prong C says that a worker who's customarily engaged in an independent business or industry would take steps to establish their independence. So this type of entity, they'd form a corporate entity, they would create business cards, have their own business license, phone, location, have other clients. It's not enough for the hiring entity to prevent that worker from engaging in other work. So you're not going to meet that step of the prong just by saying, oh, well, I didn't prevent our independent contractor from working for other people. That's not enough. And again, using your own equipment is not sufficient to establish independent contractor status by itself. So there are tax and insurance liabilities for misclassifying people. The way that a business can get in trouble is if a worker presents a case through the labor commissioner or civil court saying that they've been misclassified as an independent contractor rather than being an employee, and then they will sue you for those missed meal periods and rest breaks and overtime and minimum wage, those types of things. So if someone is misclassified, they can get not only their missed time, but treble damages, waiting time penalties, which can be their daily rate of pay up to 30 days. They can get attorney's fees, and there's major fines if you have not provided workers' compensation for those workers. The tax implications is that if you have not properly withheld federal and state taxes by using independent contractors, then there are various tax liabilities, which you see on the left-hand side of the screen. Just even having misclassified one person can be $5,000 to $25,000 of liability. So this is one thing that we've been talking to our clients about, is how do you convert people and make them happy? You know, when you now have to pay for payroll and workers' comp and all these other payments for making someone an employee, those costs add up. And you may need to drop someone's hourly contractor rate to a lower salary, you know, in order to keep your business open and justify those things. But there's other ways to compensate your independent contractors to get them to sign on to this new notion of being employees. So there's employee benefits that you can offer them, stock options, paid vacations, you know, they get sick days, life insurance, disability insurance. There's some programs that you can offer at a, you know, greatly reduced rate that's very attractive. So if you have an independent contractor that has done great work for you and you want to keep them on, but you're going to have to lower their hourly rate in order to make them your employee, just think about some of the other ways to make this attractive. You can also put together commission payments or bonus structures that keep them enticed so that they'll want to continue helping your business. So what you should do now is talk to counsel, make sure that you are properly classifying your workers. You may need to convert those independent contractors to employees, and there are onboarding requirements when you make someone an employee. You have to give them a W-4. There's labor code section documents that you need to provide them with. You need to get the workers' compensation in order and get some help in understanding all the various laws that apply to your business depending on how many people you're going to be bringing on as your employees. In California, you can be sued for harassment having one employee, but after you have 5 employees, there's a whole host of other laws that now apply. And then as you get bigger, there's further laws that you need to comply with. And you may need to vet your vendors differently. Some people have asked whether they can get around these laws by just hiring a staffing agency. And the staffing agency will then take care of the onboarding and some of the, getting the workers' compensation. And the law is saying that a staffing agency is not by itself a protection because you have joint liability. If that staffing agency is not correctly paying its workers their minimum wage, their rest and meal periods, for example, when they go to sue, they would certainly name your hiring entity and the staffing agency. So you want to contract with staffing agencies who are going to show you their due diligence of how they pay their workers and their policies and procedures to show that they're doing things correctly. So now I'll open it up to questions. Hopefully I haven't scared anybody too much, but I know this is a big change in the law and a lot of people are scratching their head as to whether they now need to convert all of their contractors. So if you have any questions, I'm happy to answer.
There's no Q&A in the queue right now. So I don't know if everyone understands how to type into the Q&A queue. You should have a button on your screen that allows you to do that. Do you guys see it? No, I can't hear anyone. So if you scroll down to the bottom of your screen where our presentation is, you should be able to. Okay, well, here's a question that came in, not into the Q&A. Don't professional employer organizations protect businesses from liability?
Not entirely. And so that was what I was talking about with using a staffing agency, is that you as the hiring entity can still be on the hook. There are certain contracts and indemnification agreements where a PEO might say, if you get sued, we will indemnify you if we didn't do it correctly. But in terms of Dynamex, having a staffing agency isn't enough of a protection.
Are there any questions? You can use the chat if you want to go in and ask a question. Because right now, it's only set up not to do verbal questions. So if you, like I said, I know that one person's typing in questions. You can go down on your Zoom. Okay, here's one. Thank you for the concise information on this important topic. What state do you suggest businesses move to?
Oh, I know, and we hear that a lot. California is definitely one of the toughest states to do business in. But a lot of states are looking at what California is doing with this decision and saying, oh, well, we can get our tax revenue back too. So I expect to see many more states that are going to follow suit with this Dynamex decision. Although I also expect that various industries are going to ask for carve-outs where applying this law just really doesn't make practical sense. I think we'll see a lot of lobbying with the legislature to say our industry doesn't apply and take us out of this decision. But until we have those carve-outs, this is the legal landscape that we're dealing with.
Are there any other questions? I mean, can you, if you have one, make sure you put it into the chat screen or the Q&A screen. I know for us here at the Chamber, and this might be food for thought for people, we hire people sometimes as an as needed basis. Maybe it's to sell sponsorships, maybe it's to come in and just do our bookkeeping like once a month. So let's just say it's a bookkeeper, Alexis. Like, does my bookkeeper now fall under the independent contractor ruling? Because obviously I need a bookkeeper to function.
Yeah. Bookkeeping to me is one of the grayer areas with this, because everybody needs bookkeeping to do the usual course of their business, to run, the transactional part of their business, whether it's goods or services. So the technical answer is yes, they should be your employee because it's the usual course of business. That third prong about whether the bookkeeper has their own corporate entity, are they working with hundreds of clients? Are they holding themselves out to the public as being an independently established business? Are you paying their company's invoice, corporate invoice, as opposed to giving that person a 1099 at the end of the year? These are things to consider. But the safe answer and the compliant answer is yes, that bookkeeper should now be your employee.
So they're an independent bookkeeper. They're not incorporated. I 1099 them because it comes to over $600. I now have to make them an employee.
Yes, because any 1099s that you now have on your books, you are risking an audit.
Okay, so we have another question that came in. What agency is expected to provide clarity to this general ABC ruling by the Supreme Court, and what is the expected timing?
There's no expected timing. I think the various industries are going to lobby the legislature to see if there's going to be some further interpretation, of which industries this applies to, but it could take years. And so that's why, the people who are saying, well, just wait and see, and I'm sure this will change, we have to deal with the law that we've been given as of April of 2018. So to be compliant and to be safe, you do need to convert, and that's what employment lawyers all over the state are telling their clients is, you've got to get those 1099s off your books because you are subjecting yourself to risk. I think I talked earlier in the webinar about how an individual can bring a case and say that they were misclassified, but certainly the labor commissioner can perform audits. The state can perform tax audits and see if you are classifying people properly. So it's not just about whether your independent contractors are going to bring a case against you. If you're subject to an audit, they're going to take a look at who are your employees, who are your independent contractors, what do they do for you, how are you paying them, do you provide workers' compensation, and that's where the penalties can really significantly add up.
So if right now you have a person that's a 1099, and let's just say you didn't even know about this ruling until July, and you still are going to 1099 them at the end of the year, you're subjecting yourself to an audit?
Potentially. I mean, as with most of these cases, if they go before the auditor, you're going to argue your good faith. So if you've since learned about this law and made steps to convert people and take a look at your hiring practices, that's what you're going to argue to reduce any penalties that might be assessed against you. But let me emphasize that this is not a new law, and it's being applied retroactively in the sense that the previous tests that we were working with, Borrello and Martinez and the common law standards, they all assumed that people are employees. It's just that the court had left us with more factors to try and argue, no, this person really should be an independent contractor, or this person should be an employee. Now we don't have all those factors to rely on. We have this three-part test. But the court is looking at it as, this goes back to 1916 when we had various labor wage orders that said that people are presumed to be employees. So the court's not seeing this as a new law.
We have another question. So if the independent contractor incorporates and you are paying their corporation instead of the IC, does that protect you? The
answer to that is Not 100%. The only 100% safe way is to make those people your employees. But you have to look at the cost of business and of doing business in California and what you can afford. And, you know, you're gonna weigh the risks of what if I am audited and I've not paid this person properly, and am I subject to a willful misclassification penalty of potentially $25,000 and all of this person's missed meal and rest periods for 3 years. That's the statute of limitations that the court will look back is 3 years or 4 years if it's a willful violation of the law. That's a much higher standard to prove. So most cases go back 3 years. But no, it's not enough just to work with someone who's incorporated if really what they're doing for your business is part of your usual course of business.
So going back to the bookkeeper thing, so we have a bookkeeper and they decide to incorporate. So it doesn't protect me now that they incorporate and I'm paying their company?
It's a good argument for you to make that they are an independently established business, because they work for hundreds of clients. They hold themselves out to the public as being independent. You don't control their work. They, you know, do they do the work outside of the office, maybe at their own office? So, you know, you have an argument to make, but I can't sign off on that and say, yes, 100% you'd be protected.
What does this do to the sole proprietor then that isn't incorporated, but still isn't in your office, that has bills out to you? What does that do to them?
They should be your employee to be safe. You know,
this rule effectively get rid of any sole proprietor businesses then that provide services to their companies?
The court gives the example of if you're a doctor's office and you bring in a plumber to fix a broken toilet in your doctor's office, that person could be an independent contractor under this rule, because plumbing is not the usual course of business for a doctor's office. But it's a very limited exception that that's going to apply to.
So anything like for instance, I'm going to go back, Chambers of Commerce, we do directories. And the directory company is a corporation, and then they hire a salesperson and they're paying that salesperson. We get invoiced by the corporation. So does that mean that the person that they are assigning to us, even though we may never see them, they never come in our office, they do everything outside, that they become our employee even though we're being invoiced by a corporation?
It means that if the corporation is not paying them properly and you get sued by that person saying, I'm doing directories, that's what the chamber does, it's the usual course of business, I shouldn't have been an independent contractor, that they could go after you for those monies as well.
So this actually could open up lots of businesses to lawsuits if you have the wrong person working for someone.
Correct. So you really need to, like I said, you need to do your due diligence with your vendors. You may want to have some checklists. You know, do you pay workers' comp? How do you do your payroll? How, you know, what are your hiring practices? Talk to counsel about creating some language that's more protective of your business.
Okay. We have another question. This is one of the ones I mentioned to you earlier about the contractor. I have a company I use to finish work. We have done 90% of the work already. They send me an invoice from their business and I pay them. Aren't they a contractor on their own?
I'm sorry, were you saying a general contractor?
Well, yeah, this is one of the ones we were talking about prior, you and I were talking about prior to the webinar starting. So someone's a contractor and they've already done 98% of the work, but 2% needs to be finished, like the framer or whatever you were talking about earlier.
Right.
They send the company an invoice from their own business and then our company pays them. Aren't they a contractor for the other company?
No, so this is what I was giving the example of, is if you're holding yourself out to the public, say the example is you're building a house and part of building that house is using an electrician, Technically, under Dynamex, that electrician is part of the usual course of business because your end product to the customer is the house. So I spoke to a construction group about this. They were completely up in arms. Understandably, it's very frustrating. But the way we have to technically read this law until we have any further clarification is that the electrician becomes the employee as well. And I just want to read you a footnote from the case that's directly on this point. Hold on one second. Okay, so the court gave this example, and this is a Maine case, but California was citing it in Dynamex. And they said that the example that they gave was the cutting and harvesting of timber by an individual worker was work performed in the usual course of business of the plaintiff's timber management company, whose business operation involved contracting for the purchase and harvesting of trees and the sale and delivery of the cut timber to customers. Rejecting the company's contention that the timber harvesting work was outside its usual course of business because the company did not currently own timber harvesting equipment itself, the court upheld that the harvesting work was not merely incidental to the company's business, but rather was an integral part of that business. So, you know, in the construction industry, just to say, well, we don't even have the equipment to do that work or the people who have the expert knowledge to do that work, which is why we contract with others, the court said that's not enough. That just shows you how broadly this law is being interpreted.
A follow-up from the same person is, so they're their own incorporated business. And you still have to somehow how do you make that person the employee then if they're already incorporated and sending that person to you to do that 1% of work?
So again, in that situation, I think it's really important to do your due diligence for that vendor to make sure that they are properly covering their employees with workers' compensation, and you have the right as that general contractor to see their payroll practices. There's actually a statutory exception for general construction that says because you could be a joint employer in this situation, you have every right to open up their payroll books and see how they do things. It's administratively a very difficult burden for the general contractor, but that's something that you should talk to counsel about, again, in looking at your contract and what the subcontractor might indemnify you for, you know, if you're brought into a lawsuit because of improper payment.
You know, I keep using the bookkeeper as an example because we all have bookkeepers, and that's a lot of our members are small businesses, and some of the people on this call are. And so, with just the bookkeeper scenario, that person is a sole proprietor all by himself. They don't hire anyone else. They still, with the exception of not being incorporated, they still invoice you. So. Right. You're gonna look at them for workers' comp. When you're a sole proprietor, you don't pay workers' comp for yourself. Because you're not incorporated, you don't have to. When you're, you also don't fall into it like a lot of the other things you mentioned. You know, you don't fall into because you're your own business and you're all by your lonesome in that right. business. How does this apply?
Again, I think the person should be made an employee, and they may be employees for 50 different companies. I mean, that's the frustrating thing about this law, is that the practicality of it is very difficult to comply with. But the way that we read this, if bookkeeping is the usual course of your business, just like sales would be, then those people need to be your employees if they're not incorporated and have many of the other markings that you can argue that they're an independently established business. You know, I see CPAs and lawyers as being, you know, falling very squarely into that C part of the test of being an independently established business. Bookkeepers, for me, it's a little bit more of a gray area.
Okay, we have another question. Someone else in the construction industry, they're a trucking company. So they're generally the sub or other subcontractors. And are we all considered employees of the general contractor, or is each subcontractor's crew employees of whatever sub hires them? In short, how does this work on a large project with multiple tiers of companies?
So the compliant a compliant way in meeting Dynamex's ruling is that everyone would be the employee of the general contracting management company. But in practicality, most people are the employees of their subcontractors. And again, that's where you'd want to discuss having some protective language between the general contractor and the subcontractor, and do your due diligence to make sure that people are being paid properly and covered properly.
Okay, I just want to make sure. Dawn, you just asked that question. So if that answered your question, let me know and type back in, because I know the contractors have so many subs. We have a member that they build high rises, and they have their electrical contractors, and then they have their contractor who just builds their parking lots, and those are all corporations, you know, that they are getting paid by the corporation, not by the main company that's building the high rise.
Right. So I think, like I said, I think you have a good argument when the person is incorporated and they are covering their employees with workers' comp, and they're paying minimum wage, and they're giving people their rest periods. Then you have some peace of mind that you're doing things correctly. But if you got audited, it's most likely you're going to be considered a joint employer of the people who are underneath the subcontractors corporation.
Okay, so Dawn followed up with, so are we expected to carry workers' comp on trucks that they hire? They're a trucking company. Or is that now the general contractor's responsibility?
I'd have to do a little more research on that, to be honest. Because again, this really, this case affects the wage orders. It doesn't apply to every aspect of somebody being an employee or a contractor, and you can have different tests that come out with different outcomes. So this really just applies to, again, over time, whether you have coverage for them and minimum wage. I would have to look into that workers' comp issue.
Okay. Are there other questions from the group? I mean, obviously, I don't have you where you can talk. I could allow everyone to talk really briefly if you wanted to just chime in, because we have a few more minutes. So I'm going to kind of let a few of you talk right now. So I just let Alberta in, and Dawn, and Bob, and Jeff, Michael, Steve, Yelena. Do you guys have any questions that you want to ask? For some reason, you're on mute. No, maybe you're not on mute. Any questions from anyone? Unmute, unmute, unmute. I'm just learning this program, don't forget. I don't know why it's not unmuting you guys. Okay, so if there's no further questions coming in right now, I just want to tell you really briefly, in the meantime, you could think about if you have anything for Alexis, that the California Chamber, in response to the significant implications of this new ABC test, they've led a group called the I'm Independent Coalition, which is a coalition of effective workers and businesses. The coalition is going to continue to work at having legislation to introduce the new post-election session that will provide solutions and protect the ability to work independently or freelance. So I'm going to send out a link to that, and you're all obviously on your own all welcome to sign up for that coalition. We're not advocating it. I'm just letting you know it exists, because I know we've had questions from other members saying, how do I get more involved? And it's just one way to get involved. Obviously, Alexis, can answer more questions for you if you like. And following this, you are going to get a follow-up email for a survey. There was one more question for Alexis. Is there a flyer that will be helpful that can be shared, so they understand, like how you mentioned some things about doing your due diligence and what things they need to ask? Is there something that we could provide them?
I have an email that I've given to my clients. I'm happy to forward that to you, Nancy. It has a kind of a brief breakdown of the Dynamex case and the what you need to do to convert and the implications of it.
Okay. So if there's no other questions, we can just end this session. And I'm going to leave Alexis's number up here on the screen until we end this. This is recorded, so it will be available later for our members, and we're trying to see where we're going to put it on our website. But in the meantime, I want to thank Alexis for joining us today. She is a member of the Chamber like all of you, and hopefully you can meet her at one of our other events. And her, as I said, her number's on the screen, which is 818-591-6724 in case you shut off your screen. 818-591-6724. Thank you everyone for participating in today's webinar, and we look forward to talking to you soon. With that, I'm going to end the session. So everyone have a great day.
Thanks, Nancy.
Thanks, Alexis. I'll talk to you in a few minutes. Bye-bye.
Okay.